The views and opinions expressed in this learning module are those of the general employees that we have studied during our surveys and do not necessarily reflect any specific employees present here or anywhere else. This learning module is made specifically for the sensitization of employees for the issues of sexual harassment of women at workplace. It should not be utilized or counted as a compliance as per the Sexual Harassment of Women at Workplace Act, 2013, Prevention, Prohibition, Redressal. The Honorable Supreme Court defines sexual harassment as any sexually determined behavior which may be unwelcome, physical, verbal, or non-verbal conduct. According to Articles 14, 15, and 21, sexual harassment is gross violation of women's right to equality and dignity, and calls for prohibition, prevention, and redressal. Today, all workplaces in India are mandated by Sexual Harassment at Workplace Act, 2013, to provide a safe and secure working environment for all women. An effective implementation of the Act will contribute to the realization of their right to gender equality, life and liberty, and equality in working conditions everywhere. You must always stand up and speak out. Welcome to Awareness on Prevention of Sexual Harassment e-learning. Upon completion of this e-learning you will be able to understand sexual harassment at workplace, and types of gender discrimination. Identify some common forms of sexual harassment at workplaces. Prevent sexual harassment through timely response from complaints committees. Act against sexual harassment through proper complaint mechanism. Before we begin with the course, here are some scenarios for you to analyze and identify if it is a case of sexual harassment at workplace. Are you ready? Let's get going then. A female trainee is demanded to stay back late night by a senior colleague to discuss a project, even when she is not a part of it, and none of the other team members are staying back. She finds his approach sexually implicit, and reports it. Would you consider this as an act of sexual harassment? That's right. A group of employees stand outside after their shift is over and sing songs with sexual connotations as and when their female colleagues pass by. Will you report this as a case of sexual harassment at workplace? That's right. A female employee is suddenly terminated from services after she reported sexual advances by her manager during a company tour. Will you report this as an instance of sexual harassment? That's right. A colleague often displays pornographic material on his mobile phone and invites you to watch it. Would you register this case as sexual harassment? That's right. A housemaid is forced to stay at her employer's house, and not allowed to meet her parents or relatives. Is this an instance of sexual harassment? That's right. Let's understand what sexual harassment at workplace indicates. It is bullying, or coercion of a sexual nature, which is usually unwelcome, or an inappropriate promise of rewards in exchange for sexual favors. In most modern legal contexts, sexual harassment is illegal. In essence, sexual harassment is a mirror reflecting male power over women. Here are some common types of gender discrimination found at most workplaces. These are: discriminatory questions asked at a job interview, not hiring prospective employee, denial of promotions, illegal termination of services, unequal wages for the same work. Generally, workplace sexual harassment refers to two common classifications of inappropriate behavior, or sexual harassment at workplace. First, quid pro quo, which literally means this for that. For instance, direct or indirect promise of preferential treatment in employment, and implied or expressed threat about her present or future employment status. Second, hostile work environment, which implies to creating a hostile, intimidating or an offensive work environment, and humiliating treatment likely to affect her health or safety. Apart from quid pro quo and hostile work environment, sexual harassment at workplace can be further classified as verbal, non-verbal, and physical. Examples of verbal sexual harassment include unwelcome compliments and offensive jokes, both of sexual nature. Examples of non-verbal sexual harassment include displaying sexually suggestive pictures, calendars, or posters, and/or staring, leering, or making lewd gestures. Examples of physical sexual harassment include sexual advances such as touching, patting, or pinching, impeding or blocking movement or any physical interference with normal work or movement. Sumatha has been working as a business executive with Growtech firms since 1 year. She has refused an offer made by a senior officer for a sexual relationship. Sumatha has kept quiet about this experience, but thanks to the gossiping senior officer, she was acquired a reputation of being a woman of easy virtue. Now she is being subjected to repeated advances by 3 of her senior colleagues. When she turns around and protests, she is singled out and bullied. Which form of sexual harassment is Sumatha experiencing at work? That's correct. It is a form of hostile work environment. In the above scenario, Sumatha's refusal to the sexual advances made by her senior officer leads to her being subjected to rumors, gossip, character assassination, and unwelcome sexual advances by other officers. We have collated some scenarios based on real-life experiences of women at workplaces. These scenarios are demanding sexual favors, singing songs with sexual connotation, cracking awkward jokes, discrimination, gender-biased insult, obscene gestures, hugging, touching and molestation, displaying pornographic material, unwanted touching, and abuse of authority or power. Click on each scenario to learn more.
Will you come in my cabin and give me a good massage?
Making unsavory remarks, or singing songs with innuendos. Cracking jokes, which cause awkwardness or embarrassment.
You are just a woman. We need a man for this assignment.
Using gender-based insult or sexist remarks. Making obscene gestures, or using indecent language, unwelcome sexual overtones in any manner. Hugging and touching any part of the body, repeatedly on some pretext or the other. Displaying pornographic, or other offensive, or derogatory pictures, cartoons, pamphlets or sayings at the workplace. Physical confinement against one's will, and any other act likely to violate one's privacy, like standing too close, and trying to touch, or feel. Threatening adverse consequences on raising objections, or resisting sexual advances. Prevention is the most effective weapon of working women against sexual harassment at workplace across all sectors. Empowered women are key to a nation's overall development, which is only possible if they have a safe and secure environment for work. Hence, complaints committees at all workplaces are now charged with the role to ensure that the right remains intact, through a fair, informed, user-friendly process of redress. Before 1997, women facing sexual harassment at workplace had to lodge complaint under Section 354, that deals with criminal assault of women to outrage women's modesty, and Section 509 of the Indian Penal Code, that deals with word, gesture or act intended to insult the modesty of women. Sexual Harassment of Women in the Workplace Act 2013 recognizes that with India's ratification of CEDAW, it is obligated to women's protection against sexual harassment and provide the right to work with dignity. The Act considers sexual harassment to be a violation of the fundamental rights of a woman to equality as guaranteed under Articles 14 and 15, and her right to live with dignity and free from violence as per Article 21 of the Indian Constitution. It has also been considered as a violation of a woman's right to practice, or to carry out any occupation, trade or business under Article 19(1)(g) of the Constitution, which includes the right to a safe environment free from harassment. This new Act also takes into its ambit the judgments made by the courts of India while trying the various cases of sexual harassment at the workplace, as defined by the Vishaka directives. The matter came before the Honourable Supreme Court via a public interest litigation, or PIL, filed by NGO named Vishaka, urging for judicial intervention, to make workplaces safer for women due to the legislative inactivity in this regard. The Honourable Supreme Court observed that India was already a signatory to Convention on Elimination of All Forms of Discrimination Against Women, or the CEDAW. It thus read the provisions of CEDAW, signed by India in 1980, in Articles 14, 15, 19 and 21 of the Constitution. It also laid down binding guidelines to be followed by every private and public sector employee to ensure the dignity and safety of women in her place of employment. Identify the primary objectives of the Sexual Harassment of Women at Workplace Act, 2013. That's correct. The primary objectives of the Act are protection against sexual harassment of women at workplace, prevention and redressal of complaints of sexual harassment. A safe workplace is a woman's legal right, and the responsibility of her employer. Ensuring safe working conditions for women leads to a positive impact on their participation in the workforce and increases their productivity, which in turn benefits the nation as a whole. However, even today, approximately 93% women workers who are employed in the informal sector remain unprotected by the law. Given the largely intangible nature of workplace sexual harassment, there are also a range of complexities involved in responding effectively to workplace sexual harassment complaints. With no laws or mechanisms to protect them, proactive measures are required to make their workplace safe. A workplace is defined as any place visited by the employee arising out of, or during employment, including transportation provided by the employer for undertaking such a journey. As per this definition, a workplace covers both the organized and unorganized sectors. It also includes all workplaces whether owned by Indian or foreign company having a place of work in India. Click on each tab to view employers listed under government offices, private firms, and dwelling houses. The heads, or specified officers of, workplace of central government, state government, local authority. Persons responsible for private limited companies, public limited companies, semi-government organizations, MSME, micro, small and medium enterprises, PSUs etc. Individuals benefiting from women's employment in residential complexes, clubhouses, apartments etc. A complaint committee must be constituted in every workplace so that every working woman is provided with a mechanism to redress her complaints. The Act provides for two kinds of complaints mechanisms: Internal Complaints Committee, ICC, and Local Complaints Committee, LCC. The purpose of the complaint committees is to educate and sensitize about the issue of sexual harassment, and to address complaints and conduct inquiry. All complaints committees must at least have 50% representation of women. ICC or LCC members will hold their position not exceeding 3 years from the date of their nomination or appointment. Let's take a look at the administrative structure of the ICC and LCC. An internal complaint committee of any workplace comprises of a chairman, or chairperson, who is usually a female employee working at a senior level, 2 members from amongst the employees committed to the cause of women with legal knowledge and experience in social work, and external member, who should either be from an NGO with an experience of 5 years in sexual harassment-related matters or an advocate. A local complaint committee of any workplace comprises of a chairman, or chairperson, who is usually a female employee working at a senior level, 2 members from amongst the employees committed to the cause of women with legal knowledge and experience in social work, and external member, who should either be from an NGO with an experience of 5 years in sexual harassment-related matters or an advocate. An ex officio member dealing with social welfare of women and child welfare in the district. Here is a list of guidelines that both the internal and local complaint committees should follow. These are: be thoroughly prepared, know the Act, policy and/or relevant service rules, gather and record all relevant information, determine the main issues in the complaint, prepare relevant interview questions, conduct necessary interviews, ensure parties are made aware of the process and their rights or responsibilities within it, analyze information gathered, prepare the report with findings or recommendations, maintain confidentiality, and be impartial. Any aggravated woman may make a complaint of sexual harassment at workplace in writing. She can make the complaint within a period of 3 months from the date of incident, and in case of a series of incidents, within a period of 3 months from the date of last incident. The time limit may be extended for another 3 months if the complaint committee is satisfied with the reasons for non-filing. If any woman is unable to make a complaint in writing, then the complaint committee should provide assistance in doing so. Let's take a look at who can complain on behalf of any aggrieved woman in case of her physical incapacity, mental incapacity, death, and in case the complainant is unable to file the complaint for any other reason. 6 copies of the written complaint should be submitted to the complaint committee. The complaint should contain a description of each incident including relevant dates, timings, and locations, name of the respondents, the working relationship between the parties, and compliant content. Upon receipt of the complaint, the complaint committee should review it to ensure it has all information, that the conduct of respondent was towards complainant and form of sexual harassment at workplace. The incident occurred in workplace or at any location or any event related to work. Send complaint to respondent within 7 days of receipt or respond within 10 days. Meet up with complainant for any settlement or conciliation. Let's quickly take a look at the timelines for the following. Submission of complaint within 3 months of the last incident. Notice to the respondent within 7 days of receiving copy of the complaint. Completion of inquiry within 90 days of complaint. Submission of report by ICC or LCC to employer or district officer within 10 days of completion of inquiry. Implementation of recommendations within 60 days, and appeal within 90 days of the recommendations. It must be noted that the Act prohibits the disclosure of contents of the complaint, identity and address of complainant, respondent, and witnesses, information pertaining to conciliatory or inquiry proceedings or recommendations of the ICC or LCC, action taken by the employer or district officer. In case of breach of confidentiality, the service books direct a fine of 5,000 Indian rupees, which should be collected by the employer. Any successful preventive strategy demands the involvement of all parties with a clear intent to fight against sexual harassment at workplace. Click on each tab to learn about the responsibilities of both employers and employees. Provide safe working environment for women employees. Display conspicuously at workplace, like display of penal consequences of indulging in acts of sexual harassment. Organize workshops and awareness programs for sensitizing employees on the issues of sexual harassment. Take steps to prevent and deal with harassment in the workplace by creating complaints committees. Establish written anti-sexual harassment policies. Employees must also actively participate in the prevention of sexual harassment at workplaces. They should refrain from engaging in potential sexual harassment behaviors at work. Be aware of the various forms of sexual harassment. Discourage inappropriate behavior or conduct at workplace. Understand the organization's sexual harassment policy. Confront any harasser immediately to let him know of the misconduct. Document all incidents of sexual harassment. Provide support to a complainant throughout the complaint process.